thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the Queen, the public weal and the peace and the tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity one towards another, through Jesus Christ our Lord.
Seated, please. This Honourable House now resume its sitting. Call of the roll.
Mr. Whittle, Mr. Samuda, Mr. Holness, Dr. Clark, Mr. Shaw, Dr. Chang, Mr. Montague, Ms. Grange, Mr. Henry, Mr. Bartlett, Mr. Mackenzie, Mr. Chuck, Mr. Darrell Vaz, Mr. Mrs. Williams, Mr. Warmington, Mrs. Robinson, Mr. Hutchinson, Dr. Wheatley, Dr. Tufton, Mrs. Malahoo Ford, Mr. Spencer, Mr. Green, Mr. Green, Mr. Terry Long, Mr. Main, Mr. Holness, Mrs. Williams, Mr. R. Scott, Mr. Azan, Dr. Bloomfield, Mr. Brown, Dr. Brown-Burke, Mr. Buchanan, Mr. Bunting, Dr. Campbell, Mr. Leslie Campbell, Mr. Clark, Mrs. Cuthbert Flynn, Ms. Daly, Mr. Daly, Mrs. Dalrymple Philibert, Dr. Dunn, Mr. Fagan, Dr. Ferguson, Mr. Golding, Dr. Guy, Ms. Hannah, Mr. Hales, Mrs. Holness, Mr. Hilton, Mr. Jackson, Dr. Clark, Mr. Kellier, Dr. McNeil, Ms. Nita, Mr. Paulwell, Mr. Michael Phillips, Dr. Phillips, Mr. Pickersgill, Mr. Redmond, Mr. Robertson, Mr. Robinson, Mr. Stewart, Reverend Thwaites, Mr. Dwayne Vaz, Mr. Wright.
Statements by ministers.
Speaker, we will be having a statement today by the Minister of Justice.
Minister Chuk.
Thank you, Mr. Speaker. Mr. Speaker, I wish to table the 2017 annual statistical reports for the Supreme Court and the parish courts in this Honourable House. This, Mr. Speaker, is quite significant as it is the first time reports of the activities in the courts are being tabled in the form of a statistical report in the House. Mr. Speaker, in May 2016, the Ministry of Justice engaged Dr. Denarto Dennis, a senior statistician, with the full support of the former Chief Justice, Mrs. Zela McCullough, on a full-time basis at the Supreme Court to develop and expand a data capture process in the courts across the island. The work of the statistician is being funded and made possible by the Justice Undertakings for Social Transformation, the JUST program, and the preliminary work on the data capture system was done by the Department of Justice Canada. This then enabled the statistician to immediately modify and implement the work of analyzing and reporting its statistical findings. Further, Mr. Speaker, the statistical personnel of the Ministry of Justice were reassigned to the Supreme Court to provide support to Dr. Dennis. Very soon after, Mr. Speaker, after Dr. Dennis was engaged, a report on the Court of Appeal was prepared and published. Mr. Speaker, a pilot project was thereafter launched in the parish courts to capture information on criminal matters and then extended to all other criminal courts by the end of 2016, then to the civil and family courts. Mr. Speaker, by the end of 2017, quarterly reports were being prepared on the treatment and disposition of matters in the Supreme Court. It is important to note, Mr. Speaker, that all stakeholders in the justice system read these reports and familiarize themselves with the concerns and challenges in disposal of cases in our courts of justice. Information is now available, Mr. Speaker, amongst other things, the number of cases in the courts, the disposal rates, the disaggregation of the types of matters in the courts, scheduling of the various matters, distribution of cases among the courts, rates for trial readiness and completion, performance rates, case loads, and the length of time it takes for matters to be completed in the various courts. Mr. Speaker, the report generated reveals that in 2017, 12,604 new Supreme Court matters were started across the 6 divisions, that is the High Court civil divisions, probate, matrimonial, commercial, home circuit, and the gun court. The major finding of the study, Mr. Speaker, was that on average, the disposal or clearance rate of cases is 49.7%. This rate ranges from 24% in the High Court and 97% in the gun court. Mr. Speaker, there are matters across the divisions that were disposed of in less than 6 months. However, on average, it takes 2 years and 1 month, that is 25 months, for a case to be concluded. In the matrimonial division, 12.6% of the cases remained in the system over 4 years before conclusion, while in the circuit court, disposal of cases took between 16 days and, amazingly, Mr. Speaker, 153 months or 12 years and 9 months. There has been improvement in this division since, for the cases filed in 2017, 41.14% of those cases were disposed of in 2017. But, Mr. Speaker, and I want members to hear this, in the probate division, a matter was completed after 39 years. After 39 years. And it begs the question, Mr. Speaker, how many other files are in the courts that may, in fact, be 20 and 30 years? So an audit has to be done, Mr. Speaker. Mr. Speaker, among the impeding factors causing the inordinate delays are the high incidence of adjournments, uncertainty as it relates to trial and hearing dates and requisitions. 69% of matters across the divisions go according to schedule. I've noticed the fact that 80.5% of criminal matters go as scheduled, while 54% of the probate matters are unscheduled. The number of adjournments in the Home Circuit and High Court civil divisions is a major cause of concern. 30% of these adjournments are owing to missing files, non-attendance of parties, issues with service, wrong listings, and outstanding documents. These, Mr. Speaker, contribute to the non-productive use of judicial time and slow rates of case disposal. Mr. Speaker, in the parish courts, 32,266 new matters were started in 2017. The average disposal rate was 69.75%, as against the international standard of 80%. What this means, Mr. Speaker, is that more cases are coming into the courts than are being assessed and disposed of, which means the backlog is increasing. In the Westmoreland and St. James parish courts, the disposal rates were above the international standard, 83.52% and 80.78% respectively. A very good report considering the heavy case load in these courts. Close behind the top two runners was the parish court in the corporate area with 76.25%. At the lower end of the spectrum were the parish courts in Trelawney and Clarendon, where the disposal rates were 58 and 37% respectively. Mr. Speaker, in order to forge ahead, it is recommended that the system allows for enhanced case and records management, more robust system of scheduling, and stronger stakeholder engagements. Additionally, Mr. Speaker, increasing the complement of judges and support staff in the High Court would lessen the caseload and positively impact the clearance and disposal rates. However, Mr. Speaker, more emphasis must be placed on alternative methods of disposal, such as mediation, plea bargaining, diversion, and dispute resolution. Mr. Speaker, the annual reports published in 2017 is on the Supreme Court website, but my hope is that it will be placed on the Parliament website and that members in this House takes the opportunity to read or look at these reports so they see exactly what is happening in our courts. Mr. Speaker, if we do not know the extent of the problem, we will not be able to effectively address it. These statistical reports have placed us in a position to undertake a clinical examination of the issues plaguing the courts and understand where intervention is required and the level of intervention that is required. The government of Jamaica, and in particular the Ministry of Justice, renews the commitment to provide the necessary resources to the court system. While this is being done, however, Mr. Speaker, all stakeholders in the justice sector can commit to maximizing the existing resources and to work together to achieve the objectives of the timely delivery of justice for all. I thank you, Mr. Speaker.
Thank you, Mr. Speaker. Mr. Speaker, I want to say how pleased I am that we have reached this point where we are now generating statistics on all aspects of the operations of the various courts in this land. It is often said that if it's not measured, it is not done. And the truth is that for many, many years, we have been proceeding with an absence of any kind of data on what the actual situation is in terms of the volume of cases going into the courts, the volume of cases that are already there, the time frames it takes to dispose of cases, and so on and so forth. One of the achievements of the JUST program, which is a Canadian government-funded program which has been going now since just after 2007 and came to an end recently, or is about to come to an end, one of the achievements was the development of the work, the preliminary work, which led to the hiring of the statistician within the Supreme Court and the reallocation of the ministry's own statistical personnel to support that gentleman. And I'm just very pleased to see that we're now actually generating usable statistics, which will help the new Chief Justice tremendously in trying to bring higher levels of efficiency to the system. There's no doubt that in Jamaica we have developed some bad practices among ourselves in the legal profession, insofar as it relates to the discipline that we approach the whole question of using court time. Far too often, matters are adjourned due to a lack of preparation of some sort or another. And judicial time is precious because we have too few courtrooms for the volume of cases that we have. So unless we use that time as efficiently and effectively as we can, we're always going to be backing up against large volumes of old cases that need to be dealt with. I look forward to seeing the details of the Statistics Minister. I believe that the 2 CDs have been tabled today. I haven't actually received them, but I would love to see a hard copy if I could. In your statement, there are a couple of surprising statistics, such as the idea that the disposal or clearance rate in the gun court is 97.86%. I'm not sure what that means, but I'm aware that there are many cases in the gun courts that have been dragging for a long period of time. And also the conviction rate in the gun court is far lower than in the circuit court, at least it was when I was minister. It would be useful to have an idea of the definitions of some of the phrases, like what is the disposal rate? What does that phrase actually mean, or clearance rate? But all in all, this is definitely a step forward, Minister. I commend you for this, and I think that it's a good day for the justice system in the sense that we're now entering an era when performance can be measured, and not just of judges, but court staff, and indeed litigants and their legal representatives, attorneys who represent them in court. And with the measuring of performance, we can start to change behavior and the culture of adjournment and delay that has befuddled administrators and policymakers for some time and has contributed to some of the problems that we have in the system. And I think that this, using the tools of accurate numbers and measurement, we should be able to improve our overall performance. And that will help the economy and doing the competitiveness of the Jamaican economy, our attractiveness to investors and so on, because the justice system is a key element in the overall coherence of the society and our attractiveness as a destination for investment. That is not often sufficiently appreciated by persons who make budget decisions, Minister. But you and I know how important the justice system is. So, Minister, I thank you for your statement and commend you for its contents.
Mr. Hilton.
Mr. Speaker, let me also say that I agree that the Minister has presented an approach to the justice system that will yield tremendous benefits going forward.
On a point of order, Mr. Speaker. Point of order. Mr. Speaker, point of order. The standing order makes it clear, and I brought to the attention of the House, that the Minister makes a statement for 12 minutes, the opposition spokesperson or the person appointed makes a response for 5 minutes. Any other member can only ask questions, and the member is making a statement. He's making a statement.
Don't do kind of food.
He's making a statement.
No.
Don't let me sit down.
Speaker.
Don't let me sit down. Mr. Speaker is making a statement. He can only ask questions. That's the standing order.
Mr. Speaker, this having to do with
Mr.
judicial...
Hilton, 1 minute. I recognize the point of order of the member, but I'm authorizing you to comment and make your question on the matter in a form of a question.
Mr. Speaker, I was simply in a way that the minister will understand, laying a short foundation before I raise the question, so that the question will be much more meaningful for him, so he can provide a response to the question. And no, please. And so, Minister, the point I wish to make is that the statistics, valuable as it is, does not, unless we're able to see.
Mr. Speaker, rise again. Mr. Speaker, the member state at the point he's making. The standing order say can only ask questions, and I'm bringing it to your attention again.
The question that is being posed, Mr. Speaker, the question that is being posed is to the minister is the extent to which factors other than that which you have indicated have been the problem for the system, among which is the training of judges themselves, given the complex nature of the matters that come before the courts, having regard to the different approaches that we're taking to economic strategy development. So in the commercial courts, for example, there are likely to be new cases, new matters, new precedent matters arising, and the question of the capability, the training for the judges in their ability to respond to these new types of cases that are coming forward into the courts.
It's all right, it's okay. Mr. Speaker, I'd just like to clarify one or 2 points. In the disposal rates mentioned, we have to bear in mind that the statistician did not go to individual cases, they just look at raw numbers. So when you say the gun court had a 98% disposal, what it meant is that in 2017, 100 cases came in. For every 100 cases that came in, 97 were dealt with, not the same 100. So the disposal rate was really comparing numbers coming in and numbers going out, but not how long those cases that were disposed of were in the system. In relation to the question from West St. Andrew, there are many other factors that will affect the flow of cases throughout the courts. In all sincerity, I believe that the courts are not managed properly. Not only the infrastructure, but the files that come to the court, how they are moved in the courts. And that is why in my budget presentation, I will make the point that we're going to put in better management in the courts, a manager maybe if ultimately for every complex, that look at not only the infrastructure, maintenance of the building, staff, but to make sure that the files flow and that no case is left behind. No file is left behind, which clearly happens because a lot of files drag out in the system for 10 years. Everybody forgets about the file until somebody wakes up 39 years later to realize that something is in the courts because maybe somebody's asking a question. We need to really flow, get the files to flow, so from start to finish within a few years, they can start and finish. And a recent case, Mr. Speaker, came out, Cameron, that has a significant impact on what is likely to happen in criminal cases, but I will comment on it at another time. Yes.
Announcements.
Laid on the table of the House today are the following. Minister Paper number 23 and the Independent Commission of Investigations Indicom Third Quarter Report 2017. Minister Paper number 24 entitled the Chief Justice's Annual Statistics Report of the Supreme Court of Jamaica for year 2017 and the Chief Justice's Annual Statistics Report on Criminal Matters in the Parish Courts of Jamaica for the year 2017. Development Bank of Jamaica, the Policy Framework and Procedures Manual for Privatization of Government Assets, the Privatization Policy, and the Policy and Institutional Framework for the Implementation of a Public-Private Partnership Program. The Emergency Powers No. 2 Regulations Continuance Resolution 2018 under the Emergency Powers Act.
Bills brought from the Senate. Petitions. Members, at this time I wish to bring to your attention that we have a new marshal, Mr. Captain Wayne Blake. I wish you to welcome him at this time. At the same time, I want to say thanks to Mr. Alan Taylor, a member of staff who carried out the duties in his absence. Thank you. Papers, reports from committees, notices of motions given orally. Prime Minister.
Mr. Speaker, I beg to give notice that at the next meeting of the House, I will move the following motion. The Emergency Powers No. 2 Regulation Continuance Resolution 2018 under the Emergency Powers Act. Whereas by virtue of Section 21 and 2B, the Constitution of Jamaica, the Governor General may make a proclamation declaring that a state of public emergency exists if satisfied that action has been taken or is immediately threatened by any person or body or persons of such a nature and on so extensive a scale as to be likely to endanger the public safety. And whereas the Governor General was satisfied that a state of public emergency existed as a result of the aforementioned circumstances, and whereas on the 18th day of March 2018, the Governor General by proclamation declared that a state of public emergency exists in the areas of the parish of St. Catherine specified in the schedule to the proclamation, and further declared that the said proclamation shall, unless previously revoked, remain in force for 14 days or for such longer period, not exceeding 3 months, as both Houses of Parliament may determine by a resolution supported by a 2/3 majority of all members of each House. And whereas it is provided by Section 23 of the Constitution of Jamaica that a proclamation made by the Governor General for the purposes of and in accordance with that section shall, unless previously revoked, remain in force for 14 days or for such longer period not exceeding 3 months, as both Houses of Parliament may determine by a resolution supported by a 2/3 majority of all members of each House. And whereas it was resolved by the House of Representatives on the 27th day of March 2018 and by the Senate on the 29th day of March 2018 that the state of public emergency declared as aforementioned should remain in force for 3 months until the 3rd day of July 2018. And whereas under the provisions of Section 3(1) of the Emergency Powers Act, it is lawful for the Governor General during a state of public emergency by order to make regulations for securing the essentials of life to the community. And whereas the Governor General, in exercise of the powers conferred upon him by Section 3(1) of the Emergency Powers Act, made the Emergency Powers No. 2 Regulations 2018 for securing the essentials of life to the specified areas in the parish of St. Catherine during the state of public emergency. And whereas Section 3(4) of the Emergency Powers Act provides that any regulation so made shall be laid before the Senate and House of Representatives as soon as may be after they are made, and shall not continue in force after the expiration of 7 days from the time they were so laid before the House of Representatives, whichever shall be later, unless a resolution is passed by the Senate and the House of Representatives, providing for the continuance thereof. And whereas the Emergency Powers No. 2 Regulations 2018 were laid in the House of Representatives on the 27th day of March 2018 and in the Senate on the 29th day of March 2018. And whereas it is desirable for the Emergency Powers No. 2 Regulations 2018 to continue in force after the expiration of 7 days from the time of the latter laying as aforesaid and until the expiration of the state of public emergency. Now therefore be it resolved by this Honourable House as follows. This resolution may be cited as the Emergency Powers No. 2 Regulation Continuance Resolution 2018, and 2, the Emergency Powers Regulations 2018, which were laid on the table of the House on the 27th day of March 2018, are hereby continued in force until the 3rd day of July 2018. Mr. Speaker, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion.
Questions and answers to questions. Motions that may be made. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sittings of the House. Motions for leave to introduce bills. Presentation of bills without leave of the House first obtained. Public business. Mr. Shamuda.
Mr. Speaker, we have 4 matters to be taken today. First of all, the Prime Minister will complete the matter that he just introduced. Secondly, we will hear from the Minister of Justice on the Child Diversion Act 2018. The debate is to be continued and closed. So we will hear from you. So I'm correct then? Okay. Third, we will have a continuation of the matter brought by the Minister without portfolio in the Ministry of Economic Growth and Job Creation, and we give the opportunity now to the member from Manchester Central, who I understand wishes to make his contribution to that debate today. So that is the third matter. And finally, we have, in fact, it's not 4, but 5. In fact, we have the newly appointed Minister of Industry, Commerce, Agriculture, and Fisheries, who will be presenting today the Protection of Geographic Indicators Amendment Act 2018, and will go on to complete the debate on the fisheries bill that was laid on the table of the House some time ago. So with that, Mr. Speaker, I invite the Prime Minister to make his presentation.
Mr. Speaker, thank you, Mr. Speaker. Mr. Speaker, at the last sitting of the House, well, I was Mr. Speaker, before I move for the suspension of standing orders, I wanted to make a few comments on the regulations. Last week, Mr. Speaker, we had a fairly extensive debate on the regulations. We couldn't have passed the regulations last week without having first have the Senate pass the extension of the state of emergency. The Senate did it in their last sitting, and so it is now for us to pass the extension of the regulations that would govern the operations of the state of emergency. Mr. Speaker, there should not be much more debate on the matter. The leader of the opposition had raised certain questions, and I believe two of them, one of them was the idea of the competent authority being a composite, being treated as a composite body. I believe that would be the proper description of the concern. And then the other issue was whether or not the minister should have the authority, should exercise the authority for, which was raised by the member from North Clarendon, to have somebody being detained in their homes, or house arrest. That was the issue. Issuing a detention order. The Attorney General's department did extensive research on the two issues that were raised. I could provide the members with the answers so as not to detain the House in any further discussion. But to deal with the matter of the detention orders, the Act requires that the minister must satisfy himself, and that has a specific interpretation in law, which means that the minister would have to consult with a competent authority, meaning in this case the Commissioner of Police or Chief of Defence Staff or both. So it is not a power that the minister could exercise in an arbitrary or discriminate way. It says he must satisfy himself. The other matter which was raised by the leader of the opposition is a little bit more complicated, in that the leader of the opposition is suggesting that the competent authority should act as if it were a composite body. The challenge in that, Mr. Speaker, is that the people who make up the competent authority in the regulations would be first of all, the Governor General would appoint those persons who would make up the competent authority. But in this case, the Governor General himself would be a part of that competent authority, because he has a power to act. He has the power to declare the state of emergency. The Chief of Defence Staff is a part of the competent authority, but the Chief of Defence Staff has specific powers vested in him or her. So too would the Commissioner of Police and the Deputy Commissioner of Police and the other senior officers who are in charge of the various areas of operations within a state of emergency. They all would make up what would be considered the competent authority. Now, from a practical standpoint, Mr. Speaker, if action needed to be taken and the law were to treat the idea of competent authority as a composite, it could significantly restrict the authority vested in the individuals by law. In fact, you would run up into a conflict. Mr. Speaker, you could have a situation where the Commissioner of Police, who sees a clear and present danger, who is empowered by law to do something, for example, have a curfew declared or do some operational things to move the forces around, would be obliged by virtue of having this composite competent authority to, instead of acting immediately, would have to now wait on and consult. Mr. Speaker, that would not be practical given the nature of how a state of emergency operates. So, Mr. Speaker, we have looked at it carefully, and we believe that the law as it is requires consultation, but it does not restrict the individual actions or the individual authority vested in any of the persons who would be part of the competent authority. So, if I may, Mr. Speaker, say that whilst we understand what it is that the Leader of the Opposition wants to achieve, which is to have greater consultation before action is taken, that consultation could, in fact, Mr. Speaker, limit or, at the worst case, result in a conflict of responsibilities where, for example, as I pointed out before, the Commissioner of Police, the Chief of Defense Staff, they are empowered to do certain things. But if at every decision they have to consult because they are part of a composite authority, a composite body, then you could very well cripple the effectiveness of the state of emergency. So we believe, Mr. Speaker, that the law as it is drafted does give the balance, does give the requirement for consultation on key matters, but we couldn't use an umbrella classification of the competent authority as a composite body. That's the understanding. So with those two responses, clarification, Mr. Speaker, I now move for the suspension of the standing orders to enable me to take the motion, notice of which I gave earlier.
Dr. Phillips, are you going to, do I put the suspension order now when you speak, or you want to make a comment on the comments?
And then I will, yeah.
There's a suspension. Those in favor? Those against? Yes, I will. Dr. Phillips.
Because I understand it, you're suspending the standing orders to enable
Yes, so could you let him
the
proceed?
motion to be tabled and taken now.
And then you follow.
I am proposing, the procedures have been varied, but that's all right. Prime Minister, I have heard your comments, but quite frankly, I am not persuaded. The first point I'd want to make, and I think it was acknowledged last week implicitly, is that we have been using a set of regulations that were originally drafted probably some decades ago. And I think we have available to us the experience of those 4 decades or so, which would warrant, in my view, Mr. Speaker, and in the view of the opposition, that we consider recasting the regulations that have been used generally in relation to states of emergency. Because we have experiences. Let me address first of all, the overall schema of the powers here. There is a competent authority. Its composition is not cast in stone, but it is in place to ensure that the major decisions regarding the administration of a state of emergency are made by this body, the major decisions. So there are, for example, in clause 8, section 8 here, a competent authority, if the competent authority considers it necessary or expedient to do so for any statutory purpose by order, for such time it may, as long as the order remains in place, stop or divert any road or pathway, cause a cordon to be set up, etc., etc. Those decisions are different from the decisions of an authorized person. An authorized person being one of the senior officers of either of the security forces. So that there is no requirement that all these persons be part of the competent authority, deputy commissioner or senior officer of police in each parish. It's a catch-all phrasing, which was put there originally, but where I think we know now that there are some decisions. In fact, this state of emergency, whether in St. James or in St. Catherine, northern St. Catherine, cannot be effectively administered without the closest cooperation between the Jamaica Defense Force and the Jamaica Constabulary Force, and indeed even outside of a state of emergency. There is a set of decisions regarding their collaboration in security matters which have to be taken jointly. And I think that it is not beyond us, and we have been raising this matter from it arose in relation to St. James, that these ought to be reconsidered, reviewed. Now, specifically, I have no question, no quarrel with the interpretation that a minister's decisions are reviewable and that he's expected to consult. But likewise, I see no problem in us stating explicitly in these regulations, if only to give comfort to the general population affected, also to give guidance to ministers that in fact this power is exercisable only upon the advice of the competent authority. And we ought not to rely on wording drawn from the 1970s, because it is the 1970s practice which generated so much controversy, unwarranted in my view, but real nevertheless. Controversy, in my view. You might have a different view. Well, that is precisely the reason why we need to put that range of possible disputes about how and why powers are being exercised absolutely beyond doubt. Let's learn from our historical experience and not end up relying on something just because we did it and there's a reluctance to adjust.
Thank you, Leader of the Opposition. I'm now interpreting your comment to say, and just to go back to the technical matter of, oh, well then, finish.
Yeah, so I am suggesting that what we need to do, and I understand that today we can't allow the security forces to be without regulations, but quite frankly, so I am not going to object to regulations being in place, but quite frankly, Prime Minister, it's the second time that we have come and said these clauses give us concern. We are taking it on trust, but we are uncomfortable with a minister having the power to confine somebody to his residence. It may be an interpretation, but interpretations rest with the courts. I want to put it beyond the realm of interpretation. We are uncomfortable with a minister having the power to vary a detention order as if he, as the wording says, is concerned. Then it would rest to any stakeholder, any citizen, to resort to the courts to prove the interpretation that you have offered. We can't solve that by simply amending these regulations. And this would apply to clauses 30, 32, confinement to a place of residence, 33, which is a detention order otherwise, in other words, to detain somebody at a place other than his residence or his residence, and to impose restrictions on who you can communicate with or not communicate with. The very point we raise, Mr. Speaker, is that these powers are extraordinary powers. You can determine, well, you know, you wrote a book on it, Mr. Speaker. You can determine who you can talk to, whether members of your family can visit you or not, whether you are able to issue a statement. Those powers ought not to be exercisable outside of the recommendation of the security forces comprised in a competent authority. And Mr. Speaker, the safeguards can be made explicit in the regulations. So what quite frankly, we don't see any injury in it. But quite frankly, what we want to say, if this is to go through here, I think we have to make it plain that we are not prepared. Our cooperation has to take into account our cooperation requires that our concerns be taken into account in this regard. We would want there to be a general re-examination of the regulations. 40 years after the original ones were used, it's time for a re-examination. And two, we want to ensure, given the lessons learned, that ministerial power cannot be exercised outside of the security concerns which would arise in this instance, or the relief concerns that might arise were it a natural disaster of some other sort. So, Mr. Speaker, those are our concerns. We had them when it was declared in St. James. We had them last week, and we have them this week. And up to now, there has been no movement satisfactory to us. I urge reconsideration to the position to be undertaken.
That you need an entirely new scheme to Well, yes, you want to review the scheme, but certainly there are things in the scheme that you're not satisfied with. So you'd want a new scheme of governing the operations of a state of emergency. Now, just to get back to the critical point of treating the idea of the competent authority as a composite body. The competent authority in the law, my understanding, refers to anyone who either the Governor General or the statute itself appoints as having the authority to act. So within this scheme, the Commissioner of Police is a competent authority. The Chief of Defense Staff would be a competent authority. They could decide, as the law says, decide which roads to block, where to put a checkpoint. They can decide on a curfew. So they would exercise the powers as a competent authority given to them by the law. Your proposal is to have all the persons named as competent authorities acting together. That was what we got from your presentation yesterday, last week.
I'm not suggesting necessarily that all the persons here, which includes or the senior officer of police in each parish, for example. I'm not suggesting that. I am saying that we have operated for many, many years with the notion of a joint high command in relation to joint security operations. That it is that joint high command which would include the chiefs of both and maybe one other senior officer, that the high-level decisions should rest with. Where are we going to cordon, how long, etc. Other decisions are for what you would call the authorized.
Okay. To thank the Leader of the Opposition for that clarity in position, because the discussion last week would seem to have wanted all the competent authorities to be acting as one mind, one body. And precisely, that's the point I'm making, that when we consulted with the AG's department, we recognized that it would take away and probably create greater problems. But the point, the more fundamental point, is if you were to compare the Emergency Powers Act with the Zones of Special Operations Act, you will see that we wrestled with the problem of the Joint Command, and we actually, in the ZOZO Act, created the Joint Command. And I'm saying that if you are proposing that this be a similar kind of mechanism, we have no objections to that. But what was said last week, I had to be guided by the Attorney General's Department on this matter. So just to be clear then, it is a good proposal, I think, that high level be there. So I'm saying that I have no objections to that. I think it would advance the legislation. The difficulty is that it couldn't be incorporated in this one. So I will accept that. Now, just to clarify, no, but it makes sense. It makes sense. The issue, however, with the detention orders, the administrative law uses language which has to be interpreted as the minister must consult in order to satisfy. The minister couldn't receive or of his own volition decide to deprive someone of their freedom of movement without being satisfied that this person should be. So the law literally requires that what a reasonable person should do to be satisfied should be done. Now, you are saying, let us make this explicit. Now, I can understand that you would want to have it is precise. We use a different, as you say, a different scheme, and we were very explicit. But it doesn't undervalue or diminish the power of the interpretation of administrative law. So, and the lawyers in this house should know that this is what it is saying. But I suspect that you would want for the layman reading it to be clear.
Lawyers differ, Prime Minister. That's why we have judges. And for every 4 lawyers, we have 6 opinions. Yeah? But ideally in this instance, both for the sake, there are many laws where they say the minister acting on the advice of. Right? We have done it many times, and we would feel comfortable in that. And I think it breaks ground. The truth is, when this type of legislation and these regulations were first conceived, and it's a matter that this House has wrestled with in many other bits of legislation, the overwhelming power of the minister depends on interpretation. Sometimes it depends on convention, but we have learned that there are ministers and ministers, there are powers and powers. These are the most extraordinary powers, suspending people's constitutional rights. We need to make it absolutely clear, that the due process here requires that it be a security matter on which non-political authority should recommend.
So, Mr. Speaker, I think this was a very useful debate. I think once the members accept that the legal terms of art that are used in the regulations now are not incorrect, but for the sake of emphasis and clarity, that we could use different language, that we accept that. Certainly, Mr. Speaker, we would not want any way to go back to the days of unsigned detention orders. We don't want to go back. Well, they were blank. Blank detention orders. We wouldn't want to go back to those days. Eh? Even that too. Definitely. We're not going back to those days. Right? I know on this side we have at least 2 members in the House who could attest, who were there, who were not mere witnesses but suffered. So we on this side well understand and appreciate the importance of ensuring that the legislation is clear, that there can be no arbitrary use of ministerial power. We are clear on that, Mr. Speaker. So, without further debate, Mr. Speaker, I now move for the suspension of standing orders to enable me to take the motion, notice of which I gave earlier.
Those in favor? Those against? As of it. Members, we are now going to require you to answer your name and yes or no, rather than we are going to vote now. Yes, go ahead, please.
Mr. R. Scott. Mr. R. Scott. Absent. Mr. Azan. Mr. Bartlett. Dr. Bloomfield. Mr. Brown. Mr. Brown. Dr. Brownberg.
Members, we are not hearing you.
Mr. Buchanan. Mr. Bunting. Dr. Campbell, Mr. Leslie Campbell, Dr. Chang, Mr. Chuck, Mr. Clark, Dr. Clark, Mrs. Cuthbert Flynn, Ms. Daly, Mr. Daly, Mrs. Dalrymple Philibert, Mr. Dr. Dunn, Mr. Fagan, Dr. Ferguson, Mr. Golding, Ms. Grange, Mr. Green, Dr. Guy, Ms. Hannah, Mr. Hales, Mr. Hales, not here. Mr. Henry, Mr. Holness, Mrs. Holness, Mr. Hutchinson, Mr. Hilton, Mr. Jackson, Mr. Kellier, Mrs. Malahuford, Mr. Main, Mr. Mackenzie, Dr. McNeil, Mr. Montague, Ms. Nita, Mr. Paulwell, Mr. Michael Phillips, Dr. Phillips, Mr. Pickersgill, Mr. Redman, Mr. Robertson, Mr. Robertson, Mr. Robinson, Mrs. Robinson, Mr. Samuda, Mr. Shaw, Mr. Spencer, Mr. Stewart, Mr. Terry Long, Reverend Thwaites, Dr. Tufton, Mr. Darrell Vaz, Mr. Dwayne Vaz, Mr. Warmington, Dr. Wheatley, Mrs. Williams, Mr. Witter, Mr. Wright, Mr. Speaker.
16 absent, 47, 16 noes. 16 noes. 16 what? 16 absent. You read it twice. 16 absent, 47 yes. Members, the result as given to me, 47 yes, 16 absent. The motion is passed. The motion is carried. Dr. Green, Mr. Green.
Mr. Speaker, it is amazing what can be achieved when we consider reasonable proposals. When they are not when we don't have an agreement, it reflects a level of shallowness of the recommendations. This appears not to have been the case. So it is wonderful that we got through that particular presentation. Now we will ask the Minister of Justice to deal with the Child Diversion Act 2018. Minister?
Mr. Green.
Thank you, Speaker. Mr. Speaker, I rise to give my support to the passage of the Child Diversion Act, Mr. Speaker. Mr. Speaker, this bill is as much about a reform of our justice system as it is about strengthening our child care and protection system. Mr. Speaker, what the bill really does is to continue to strengthen our approach in relation to how we treat with children in our nation and in ensuring that we put the best interests of the child at the center of all we do as a country. Section 3, Mr. Speaker, makes it clear that the Act should be interpreted in the best interests of our children, which is, Mr. Speaker, a significant move in relation to our justice system and our child protection system. In fact, Mr. Speaker, I think it deserves to be read in full. And it says, Mr. Speaker, that this act shall be interpreted and administered so that the best interests of the child is the paramount consideration and in accordance with the following principles. Criminal proceedings are not to be instituted against a child if there is an alternative and appropriate means of dealing with the matter. This, Mr. Speaker, is a step in the right direction. Mr. Speaker, research has shown that the best interest of the child, especially in relation to when they have gone afoul of the law, is not to focus on the criminality, but to focus on the rehabilitation of the child. Mr. Speaker, we often spend significant time lamenting the generations that come after us, speaking about how they have become wayward and the sort of activities that they participate in. But the reality, Mr. Speaker, is that children are products of their environment. And as much as we like to blame our children for their activities, especially when they run afoul of the law, we should recognize that those activities are often symptoms of a deeper problem that needs to be solved. And as such, we have to take an approach that enables us to get to the root of the problem. Criminalizing our children, Mr. Speaker, is not the answer. And in fact, I think this bill gives us a large part of child delinquency and for rehabilitation of our children in conflict with the law. Mr. Speaker, this bill makes criminal proceedings against a child a last resort. But there's also two other points that I will raise, Mr. Speaker, as I support the bill. It provides a significant expansion for the Child Care and Protection Act and allows our judges and also our police officers at the rank of a constable to, instead of instituting criminal proceedings where the child has committed a child diversion offense, to suggest and put the child on a child diversion program. It ensures that when a child is in need of care and protection and is brought before the court now has additional remedies at its disposal in relation to the child. A child can be ordered to treat with restitution, reparation. It can be sent, a child can be sent to a child diversion committee. And importantly, in our act, the Child Care and Protection Act, under Section 24, we have seen where when children are deemed uncontrollable, they can be taken before the court, Mr. Speaker, and the court has the power to order their incarceration. This child diversion bill amends that section and allows for the court, instead of ordering incarceration for children deemed uncontrollable, to order various other forms of remedies, including putting the child on a drug treatment and rehabilitation order. Again, Mr. Speaker, a step in the right direction. For me, Mr. Speaker, this is another step towards the inevitable move that we will make as a government to once and for all remove the power from a judge to incarcerate a child that is deemed uncontrollable. That is something that I know that our Joint Select Committee that is now considering the Child Care and Protection Act and other acts will treat with in short order. Finally, Mr. Speaker, another significant move is that for a long time we have been criminalizing our children, especially our boys, for what we call early consensual sexual encounters. That is where two children consent, largely exploratory sexual engagements. And what happened before, and again especially for our boys, is that these boys under the age of 16 were charged, brought before the courts, made into criminals for something that is quite a normal part of growing up. This act, Mr. Speaker, makes that offense, which falls under Section 10 of our Sexual Offences Act, a child diversion offense. So now, our children who participate in these activities as a regular part of growing up, who need more guidance than they do need the formal justice system, now they can be subject to a child diversion order. in all, Mr. Speaker, I think this bill deserves the full support of the House. Of course, it will call for additional resources right across the child protection system, the development of the Child Diversion Office, additional resources for the Child Protection and Family Services Agency, and a robust training program for our judges and our police, so that when the children come before them, they will put them on a child diversion track. But I think this will go a far way in sending a signal to the country, to our children, and to the world that Jamaica is serious about protecting the rights of our children. I thank you.
Yes, Mr. Bolian.
Thank you, Mr. Speaker. If I could borrow that, thank you. Mr. Speaker, the bill that is before us, the Child Diversion Bill, represents, along with the restorative justice legislation that was passed last year, two of the most important pieces of reform of the justice sector, seeking to provide alternate avenues for dealing with matters which would otherwise come into the court system. It is acknowledged that the court system is under-resourced, that delay is an endemic feature of the court system, and that in the context of fiscal consolidation and constraints, which is an ongoing process that Jamaica is going through as we seek to bring our public finances into a permanent state of sustainability, is likely to continue. And therefore, as much as we would like to be able to fund the justice system to the extent that is really required to get the kind of outcomes that we all want, it has proven thus far to be unattainable. And hence the strategy has been embarked on by successive governments. This is most of the justice policy initiatives that you see coming here are things that have been worked on from one government to the next, all guided by a Justice Reform Task Force report that was published in 2007 and which identified the strategies which Jamaica should be seeking to pursue to address the weaknesses and challenges faced by the justice system. So child diversion is the second piece of what I regard as a two-pronged attack or two-pronged strategy to try and handle cases outside of the court system, which can better be dealt with outside the system. Restorative justice deals with relatively minor disputes, which often in Jamaica have the potential to escalate through reprisals into much more serious crimes. And the restorative justice approach seeks to cauterize that early and avoid that series or circle of violence ensuing by healing the harmed relationships early in the process. And we have legislation in place that allows the courts to recognize restorative justice programs and refer matters that would otherwise come into the court system for adjudication through formal charges and trials to be dealt with through the restorative justice program. And it's early days yet, Minister, but I know you have high hopes for the success of that program, as do I. The child diversion program embodied in this bill is a similar concept in the sense that it looks at the possibilities of addressing children who come into conflict with the law through methodologies which are suitable for dealing with the real problems that those children face, rather than putting them into the formal justice system, which is an adversarial system where the state's role is to try and prove guilt, and the role of the victim is minimized, and the child is often victimized just by the process itself. So what this bill is all about is enabling alternative strategies to become part of the formal system of dealing with children who have difficulties, behavioral difficulties, and other difficulties that lead them into conflict with the law. Mr. Speaker, the policy that led to the development of this bill was tabled in this Parliament some years ago when I was minister. It was a very detailed policy which had emerged out of some years of work and wide consultation. And I should really recognize Miss Ruth Carey, the daughter of the late Justice Boyd Carey, who, when she was the head of the Child Diversion Unit in the Ministry of Justice, played an integral role in the development of that policy. And we are glad to see, at last, the legislation itself coming to Parliament to be passed. The drafting instructions had been issued when I was minister, and the bill is here now, and we're pleased to see that. And this is a fairly radical departure from what we have come to know as the way in which we deal with children who fall foul of the law. And it's really about giving those children a second chance through going through a process which focuses on the underlying problems that have caused them to become deviant, and trying to address those problems in a way that will give them a permanent solution that can help them to build their own lives in a lawful and constructive way. So, Mr. Speaker, I and we on this side certainly support the child diversion legislation and this bill. Having said that, I have a few comments on the bill from a closer textual analysis, which I just want to bring to the Minister's attention for his consideration in the interest of trying to make this bill as good a bill as it can be. And it is worth spending time on this type of thing in Parliament, because once bills are enacted, the process of fixing them or changing them is a long and tortuous process involving a lot of man-hours of technical time, which could be better spent doing other things if we got it right the first time. The first point I want to make, Minister, concerns the definition of diversion offense and the first schedule. The first schedule is where the offenses that are categorized as diversion offenses are listed. And there's a long list under 10 different categories in the first schedule. What I would suggest, Minister, is that the amendment of the first schedule be something which can be done by way of an order subject to affirmative resolution. Because you're going to find, as time goes by, new offenses are created. You may find that there are things that we've left out that we really want to allow diversion to be a solution for. And I think some flexibility in the legislative process would be helpful. And it's a common mechanism that we use. It involves parliamentary oversight, but it is a much simpler process to achieve an amendment to legislation by way of an order subject to affirmative resolution than an actual amending bill. So I would commend that idea to you. I notice, for example, that if you look at clause 40 of the bill, the amendment of the second and third schedule can be done by regulations. But for some reason, the first first schedule has not been included in that, and I think that should be looked at. The specific way of dealing with it, the technical people can look at. I notice also, just while I'm on section 40, that subsection 2 is really no longer necessary because we amended the Interpretation Act already so as to eliminate the provision in section 29 that had previously had a limit on the level of fines and terms of imprisonment that can be accommodated in regulations. So this, I think, section 40, subsection 2 is a relic from times past. It doesn't do any harm, but it is no longer necessary. I move, Minister, to the definition of suspended sentence order, which is on page 4 of the bill. Suspended sentence order is defined as meaning an order made by the court under section 38. However, there is also provision in section 34, 1E, for the making of a suspended sentence order by the court. And I think that there ought to be a reference to that section as well in the definition, since there are two different provisions where these suspended sentence orders are provided for. Mr. Speaker, on page 6 of the bill, in section or clause 3, subclause 2, there's a carve-out which says that the act shall not apply to an excluded offense. I have searched but not found a definition of what an excluded offense is. It sounds like a defined term, but I don't see the definition of it. I may have overlooked it, but if it isn't there, I think we should be clearer on what we mean by that, especially since it goes to the scope of the Act and is therefore an important provision, 3.2. Mr. Speaker and Minister, I move to clause 8, which is on page 10 to 11 of the bill, and it concerns the composition of the National Child Diversion Oversight Committee. This national committee is an important new body which will provide policy guidance in the area of child diversion. And its composition is as listed here: the permanent secretary in the Ministry of Justice, and that permanent secretary also chairs this national committee, or a delegate of that permanent secretary. And then, if required by the permanent secretary with responsibility for justice, a member of the Child Diversion Committee, nominated by that committee. And then it says, such other persons suitably qualified in accordance with paragraph 1 of the second schedule. It occurred to me, sir, that given that this is a national committee dealing with child diversion, and child diversion is a multidisciplinary concept, because when you divert the child into a program, you have to look at the child as a whole person and see what needs that child has to be rehabilitated, so to speak. And it seemed to me that, for example, we could consider including on the National Child Diversion Oversight Committee the Children's Advocate, the head of the CDA. These are persons who encounter firsthand the problems that children face, especially children who have behavioral challenges and so on. And I also, from experience, was going to suggest the senior judge of the family court, because in my experience, the senior used to be a magistrate, but the senior judge of the family court has tremendous experience in dealing with children with problems. And in fact, they have had to be very creative in fashioning remedies to deal with the problems of children who come before them, where the law hasn't really caught up with the needs of the society. So those are three persons who I would suggest you could consider for membership on this policy committee, because I think their insights would be of tremendous value in making the child diversion system as efficacious and powerful as it possibly can be. I move to Clause 9, Minister and Mr. Speaker. Clause 9, I had a problem with subsections 1 and 2 because it's not clear to me how the relationship between them works. Clause 9.1 says that unless the public interest otherwise requires, a child who is suspected to have committed or is charged with the commission of or has been convicted of a diversion offense may be referred, in accordance with the provisions of the Act, to the Child Diversion Committee in the parish where the offense was committed. So as long as the public interest isn't against such a referral, the child may be referred. But then when you look at subsection 2, it says a child referred to in subsection 1 may be considered for referral to a child diversion committee for participation in a child diversion program. And there's a whole list of ifs, which is if the child accepts responsibility for the diversion offense without having been unduly influenced by another person, if there is a prima facie case against the child. And this third one is the one that is most problematic to me, because it says, with the consent of the victim of the offense, if identified and located. Now, it seems to me, sir, that when you're dealing with a child, the victim of a diversion offense could be an adult. It could be another child. But I don't see why the victim should have a veto on the referral of that child into a holistic program that, instead of putting them ultimately in the prison system, where they often become hardened and end up in a cycle of returning to prison for the rest of their lives, instead can be put on a path towards a better life through dealing with the core issues that have led them to misbehave in the first place. I don't think the victim should have a veto on whether the child is referred to a child diversion program. And that is the effect, as I read it, of 9.2c. The relationship between 9.1 and 9.2 are not clear. 9.1 makes no reference to 9.2, and I think that that should be clarified. But in particular, 9.2c, which gives this veto to the victim of the offense, is, I think, problematic. If we're really accepting the idea that a child who offends ought, unless there's some compelling reason to the contrary, ought to be given the chance of being dealt with through the child diversion system. I move to clause 14, which is on page 15 of the... Oh, before I move to clause 15, there's one other point I wanted to mention on clause 9, on page 12, Minister. Clause 9.1b. It speaks to the referral to a child diversion program being made by the court, which is A, or B, in the case of a diversion offense specified in the first schedule, a constable having reason to suspect that a child has committed the diversion offense. So the police constable can himself or herself make the referral. And Minister Green made reference to that. I just want to point out clause 28.1 of the bill, because clause 28.1, dealing with referrals by a constable, suggests that before the constable can make the referral, the child must have been issued at least 3 police cautions before a referral can be made by the constable or by the police officer. That is how I read 28.1, and it wasn't clear to me how 28.1 reconciled with 9.1b. They don't refer to each other, and they appear inconsistent, and I think that should be sorted out. The next point I wish to make, Minister, is in relation to clause 14, and I thought it would have been helpful if it was clear that the child diversion program that is referred to in clause 14 as being developed by a child diversion committee, whether that is an individualized program for the particular child or some kind of generic program that a child would fit into. It wasn't clear to me which of these it was, and I thought it would be useful to make that clear. In other words, where the Child Diversion Committee is developing a child diversion program, and it's premised on the opening words of 14.1, which says, where a child is referred to a Child Diversion Committee for participation in a child diversion program, that suggests that the program ought to be tailored to the particular needs of that child who has been referred. But it wasn't clear that that was the intent, and I thought that would be useful. One thing that I found a little odd was in 14.2, where it says, in the case of a referral by the court, a child diversion program shall not be implemented if the Child Diversion Committee has not received the prior written approval of the court for the implementation of the child diversion program developed for the particular child. I found that strange. I think if the child has made a reference, has referred the child to child diversion, I don't see why, when the program is developed by the Child Diversion Committee, which is set up to do that, why they then has to go back to the court for approval of the specific program. To my mind, once the referral is made, the matter then is for the Child Diversion Committee to deal with, and there's a process in the Act of how you deal with what happens if the child completes the program or the child drops out of the program. I don't see the need to send the matter back ab initio, so to speak, to the court, for the court to approve it. And I mean, quite frankly, the courts have enough work already. I don't think we need to add more work to them, to the courts, by legislation which is really designed to try and minimize some of the burdens on the courts. I think 14.2 could usefully be deleted. I had a question, Minister, which was the child diversion programs that are developed, how will these be funded? I don't know what the numbers are, but it is likely to be several hundred in a given year of children who might fall foul of the law. And I was, these diversion programs, if they're going to be effective, need to be adequately resourced. There need to be therapists, there needs to be social workers, there needs to be the other kind of support services that can make sure that the child is benefiting in a wholesome way from the program. And I wondered what the government's policy will be in relation to the funding of these child diversion programs. And because, for example, if you look at clause 15, it says that the child diversion program developed under section 14 shall, and if you look at paragraph H, it says, be structured in a manner that enables proper supervision of the child participating in the program, and also evaluation of the effectiveness of the child diversion program by the committee. So clearly there has to be some resources allocated to this process. And there was one other question I had for you on this clause, which is subclause 14.4. 14.4 is on page 16, Minister. And it says, before implementation of a child diversion program, the Child Diversion Committee shall cause the child diversion program developed by the Child Diversion Office to be set out in writing. And it seemed odd to me. Why would the Child Diversion Committee, which I think is the parish body, have to cause the program developed by the Child Diversion Office, which is a specialist office in the central government, to be set out in writing? Surely the Child Diversion Office, if it develops a program, ought to set it out in writing. It seemed odd to me to be saying that the parish committee is the cause, the central committee, to set out the program in writing. And I just thought that struck me as strange, and I thought I should bring it to your attention, sir. I move to clause 19, Minister, and in particular 19.8, and that is on page 22 of the bill. And subsection 7 says, where a child charged for a diversion offense has been referred by a constable to a child diversion committee for participation in a child diversion program, the constable having charge of the case shall advise the court of the child's referral to a child diversion committee for participation in a child diversion program and the child's failure to comply with or to complete the program if either of those things takes place. Then 7 says, in proceeding under subsection 7, I don't think that's the right language. I think it should say, on receiving advice under subsection 7, the court shall take into account the extent, if any, of the child's participation in a child diversion program, because subsection 7 is dealing with the advice that the constable provides to the court on the fact that there has been a referral by the constable, and also on the outcome of the child's participation in the program. I noticed in clause 21(2), and this is dealing with formal warnings or police cautions, it says a constable shall not issue a formal warning or a police caution without the written consent of the victim of the diversion offense, unless the constable is unable to ascertain an individual or other person as the victim. Again, it wasn't clear to me why we have to get the victim's written consent before a police caution or a police warning can be given to a child. I think that we shouldn't give victims, I'm all in favor of victims' rights, especially in the question of appropriate sentencing and so on, and compensation. And more of our laws have provisions for compensating victims, mandatory provisions, such as the amendments recently passed to the human trafficking legislations. But I think in this instance where you're dealing with children, and you're talking about appropriate ways of punishing children, or that's perhaps not the right verb, appropriate ways of managing children who have exhibited deviant behavior. I'm not sure why the victim should have a veto on whether the constable can give a warning to the child or a caution, both of which are specific procedures in the legislation. I also made a note so that I'm not clear on what the difference is between a formal warning and a police caution. They're both provided for in 24 and 25, but it's not very clear what the difference between them is. A formal warning and a police caution. In clause 26, it says that where a constable has warned or issued a police caution to a child, A, the child shall not be charged with the commission of a diversion offense, and B, no further proceedings shall be taken for the diversion offense. And the question that jumped out at me when I read this is, supposing the child doesn't heed the warning or the caution. In other words, shouldn't the outcomes of not being charged and no further proceedings being taken be dependent on the child responding positively to the caution or warning that has been given? If the child chooses to ignore it and continues to behave in the manner which led to the caution or warning being given or made by the constable, then I don't see why the outcomes of not being charged or no further proceedings being taken should be the natural course. I thought that seemed a little odd to me. I don't have much more to go, so bear with me. I know in the House you're not used to this kind of rather pedantic exposition, but it's important. And I noticed clause 27(2), which is on the bottom of page 26, top of page 27, says, where the victim is a child, all communication with the child for the purposes of subsection 1. And this is to do with informing the victims of whether a warning has been given and a caution has been given, etc., to the child. It says that where the victim is a child, all communication shall be made by the constable in the presence of the parent or guardian. And then it goes on to say, and the constable shall interview the child to assess the impact of the offense on the child. I must say, it struck me as strange because I don't think police officers are really trained to interview children to assess the impact on them of the offense. I think if an interview is to be done, it should really be by a social worker or somebody with a requisite skill set rather than the constable, the arresting constable. So I would suggest that be thought through again. I mentioned 28.1 earlier, which was to do with where the constable is referring the child to a child diversion program, and 28.1 suggests that the child must have been issued at least 3 police warnings. And I'd ask the question, does this mean that there can be no referral before 3 cautions have been issued? That's what 28.1 seems to be saying, but it seems inconsistent with 9.1b. I'd made that point already. I think there are a couple of minor points that can be raised in committee, so I won't take them here.
Mr. Golden,
yes,
your time for speaking has expired.
I'm very nearly finished. I have I think 1 minute.
Give you a minute to complete.
Only need 1 more minute, sir.
Okay.
Mr. Speaker, we ask that the members' time be extended by an additional 5 minutes for him to complete.
Those in favor? Those against? Ayes have it.
Thank you. Thank you, Minister. House Leader. The last little point I wanted to point out it's really a minor point. It's on page 54 and 55 in the schedule, in the 4th schedule. It's just that in the definitions of in the 4th schedule, Minister, in the definition of drug treatment and rehabilitation order, and it makes reference to drug treatment and rehabilitation program, but I think that reference ought to be to a prescribed treatment program, which is another defined term further down the list. And also on the next page, in relation to the Section 14 amendment to the Child Care and Protection Act, paragraph 14.2, the new G. Again, I think it should be, rather referring to a drug treatment and rehabilitation program, it should be to a prescribed treatment program, which is a defined term being inserted into the Child Care and Protection Act by this schedule. Minister, I would just close by making reference to the statistics in the report that you have tabled today. And it is startling to me that in the Home Circuit Court for 2017, the second most prevalent charge after murder, there were 221 charges of murder brought before the court, the Home Circuit Court, in 2017, and that was 21.2% of the total charges brought. Next in line was sexual intercourse with a person under 16 years old, which was 189 charges before the Home Circuit Court, 18.16%, a large percentage of the cases that are before the Home Circuit Court. The data that we have looked at in the Joint Select Committee that Minister Green mentioned, looking at the Sexual Offences Act and other related sexual statutes, showed that at least half of those cases involve persons being charged who are themselves teenagers for consensual sex between teenagers. Yeah, boyfriend-girlfriend situations. And that is something I think we need to address urgently, because when you hear the DPP complaining about a tsunami of cases coming into the Supreme Court system, the circuit court system, because of the committal procedure, which has now started to work and free up the parish courts of preliminary inquiries, which used to take a lot of their time, so they can actually adjudicate and determine cases. We need to ensure that we don't have cases before the circuit courts, which really ought not to be dealt with in that way. And child diversion, I think, is one solution to this, but I think an amendment to the Sexual Offences Act, Section 10, to eliminate the criminalization of teenage promiscuity, which is consensual and does not involve any form of predatory conduct, I think is something we need to do quickly so that this number can go down. Thank you very much, Mr. President. Mr. Chairman.
Mr.
Daly.
Speaker, yeah. Mr. Speaker, I am going to be very brief. In fact, I only had two things I wanted to raise under the child diversion bill before us. And while I was downstairs, I saw some of them being raised in a very efficient way by the former chairman of LegCom and the member from South St. Andrew, who took us clause by clause through the bill. And the member from Southwest St. Anne will be speaking on St. Andrew, a number of issues which we spoke about. But there's one matter that is of concern to me, which I raised with the minister privately, and I thought by now would have had it clearly defined in the bill. What offenses cannot go? I was asking. No, you have the offenses that will go. But I want the country to be very, very clear that the child diversion bill that was been on the table for some time from previous minister in this 07 period and in the period when we were there until the then Minister of Youth tabled the child diversion policy in 2015, blah, blah. A lot of work has gone into it. Therefore, we need to be very precise as to what will be excluded. And I want the Parliament and my colleagues to be very clear as to what I'm saying.
Offenses that attract 3 years or more.
Come again? I can sit if you can answer me now. I'll sit. Because I want it to be very clear. Not because this child diversion policy is designed for children 18 years and under who have come into conflict with the law. That a 16-year-old boy who goes to shoot up a house and stab up and kill people should never be considered for child diversion. I want it to be very clear.
Oh, yes, absolutely.
I want it to be very clear. And if the minister is very certain on that, well, this is also what I have a problem with. Right, in this bill, I have a problem where a young, most of the gangs in Jamaica, and I asked Professor, what Professor Ariat at the university will tell you. The gang is, people recruiting to the gangs now, 16, 15, 14, former ministers of security can tell you. 16 very vicious criminals. And no, you're going to tell me that you shot a policeman, you shoot a judge, you kick down somebody's house and shoot a wife and husband and kids, but because you're 17 and the judge can decide to send that case to child diversion, the judge should never have that privilege or that power. It should be very clear. And if you commit the offense, those kinds of offense, you must pay the maximum penalty for your offense. You should never be taken to the foster homes for child diversion, you're a criminal. And you must be rehabilitated. Therefore, in prison, rehabilitated in a decent way. That is why we need good prisons. We need a decent prison. I am also, and I speak as a parent, thank God none of my kids have ever. No. That's a different thing. Mike, yeah. I speak as a parent, and all of us who are parents know that we don't know what our kids might get involved in sometime. We don't know. But if my child is to be rehabilitated, and so far none of them have ever been involved with the law, I would like them to be rehabilitated in a decent way. Not that general penitentiary, a 17-year-old put down there, or out of Spanish Town District Prison for a 17 or a 16-year-old, even if they were in the gang. So we need to move towards having decent rehabilitation facilities for these young people who have run in conflict with the law. And be certain, though, Minister, that the leniency is not extended for these criminal acts. That is all I wish to say, and I am sure members in this House on both sides agree with everything that I have to say, including you. As a matter of fact, even the chairman of LegCom agrees, because he was nodding his head. Thank you. I hope you'll address these issues when you come to close. Thank you, Mr. Speaker.
May it please you, Mr. Speaker. I rise to support this bill entitled An Act to Facilitate the Implementation of Child Diversion in the Criminal Justice System and for Connected Matters. Mr. Speaker, the law in its wisdom recognizes that children should be treated specially and differently. Children are susceptible to influence, and over time, if given the correct intervention, can be put on the right path. Experience has shown that the criminal justice system should be a last resort for the treatment of errant conduct of children. But as I listen to the very valid points that have been raised, Mr. Speaker, and in light of provisions, perhaps the bill could benefit from further consideration by the House as to what would amount to sufficient public interest to prevent a referral to the Child Diversion Committee. Clause 9, as was earlier pointed out, indicates that unless the public interest otherwise requires, a child who is suspected to have committed, is charged with the commission of, or who has been convicted of a diversion offense may be referred. The member from Clarendon spoke passionately and sought clarity on some of the matters that would be taken into consideration, and I believe that is what is captured in the public interest clause. But as has been recognized, the clause does not specify what those public interest considerations should be, and perhaps the House could consider what it would like to have included, given that so many of our offenders are children or young persons who are acting alongside adults. Mr. Speaker, but just to say that the very issue that has been raised and the passion with which the concern has been raised lends support to why we need the child diversion policy being put into law. Mr. Speaker, traditionally, you know, the retributive nature of justice demands an exact penalty. And culturally, it appears as if we know no other way but to exact the harshest of punishment on those who have gone awry. But it is especially in those circumstances that we need to put our young people on another path. But it is true to say that collectively we can determine what those public interest considerations ought to be. And instead of leaving it up to the constable or up to the court, the Parliament can give some guidance. Other than that, Mr. Speaker, I think once the issues raised are taken into consideration, we should move to implement the law and to ensure that our children are given a different and better path outside of the criminal justice system. May it so please you.
Mr. Speaker.
Mrs. Brownbrook, you may go ahead.
Thank you very much. Mr. Speaker, I use the opportunity while supporting the bill that is before us to raise some concerns that I have. I do agree that the intent is good, and this is where we need to be headed. Traditionally, the policy is really what guides the bill. And I know that there are areas where it is clear that we're dealing with children who are suspected to have committed, who are charged with, or who have been convicted of a diversion offense. My concern, though, is that in going through the bill, we seem to have left out one aspect that is normally covered when we look at the different levels at which the child diversion policy and action would take place, and that is the pre-court. So, for example, when we talk in, I think it is, totally pre-plea, no, because for some of these, totally pre-plea, even pre-plea. So, for example, if we look at clause 23, I think it is on 24, which speaks about the, where in the opinion of a constable, a diversion offense specified in the first schedule does not warrant criminal proceedings, it speaks again, it doesn't take into account what some other policies do. And what am I talking about? That when the constable or the officer issues a caution, for example, in other jurisdictions, there is a level of diversion options that are available. I believe that if we are to have a Child Diversion Act that is culturally relevant, it needs to address the issues that we are faced with in Jamaica. So, for example, crime is a serious issue committed by our youngsters who are often victims themselves. I do not see in what we have done where we have captured some of what we have identified as the root causes, and in the provisions that we have, that there is a way for us to begin to deal with those issues before we get to a higher level of delinquency. There are in other jurisdictions this happens, and I would have hoped that we would have done this with our Child Diversion Act. No, a formal warning in our system doesn't mean anything. A formal warning has to go beyond that. Because we have to go again, why is it that the child is here for me to give a formal warning? What are the issues? What intervention can we give at this point? We have been grappling, for example, with a crime plan. I remember when we did the Zozo, the most important thing that many individuals spoke about was the social intervention options that were there. And I was hoping that some of those interventions could have been captured at an earlier stage through the Child Diversion Act.
That's what the social agency is not in the court.
But that's exactly what I'm saying. It is before you get to court that there are, Mr. Speaker, I believe that given the depth of the problem that we face, we cannot be as nonchalant talking about what is supposed to be for social workers and what is supposed to be for the court. Because, in fact, In other jurisdictions, the Child Diversion Act assists in pulling in our social workers far earlier than what is being suggested here. And so I want to just place that on a record. So that, as I said before, that there is an intervention way before a diversion offense has in fact been committed. Page 7. Clause 5. Clause 4.2. No, let me leave that for a minute. In clause 5, it speaks to the child diversion office and what they should be responsible for, as well as the child diversion oversight committee for each parish. And it goes through a number of things that they are responsible for. I note at 5F that it should facilitate, prepare, and conduct training programs from time to time for the judiciary, constables, correctional officers, public officers, and the public as necessary. I believe that a training program is something totally different from a public education program. And I believe that a public education program is warranted, and which is separate from the training program of those individuals who are going to be directly involved in the administration and implementation of the programs. There also is, I believe, a role or a place for us to recognize what we have been lamenting for a number of years, which is that the old adage of it taking a village to raise a child seems to be disappearing. So I think, Mr. Speaker, that there is an opportunity to ensure that the village is empowered through public education. For example, you would already know, I'm sure, Minister, through the Speaker, that there are communities that have taken responsibility for their children, that have set time for children to be at home, not on the street. So if we can have communities doing that, then I suspect that if properly empowered, our parents and members of the community could also play a role, because they understand very clearly what are the options open to them, which again is why I would have wanted to see also that some of the other issues that might not amount to criminal offense be captured as well. When I look, I go back again to the root causes. What are those issues that our research has found that makes our young men and women, and girls quite frankly, and women, more susceptible to being taken in by the gangs? What are those things? And how are they dealt with? What option is there to deal with them through this Child Diversion Act? At 7F, Clause 7 speaks about the Child Diversion Committee, and again, what they should be doing. At F, I know that they would also be conducting research, studies, evaluations, and other studies, and collecting data on matters relating to child care and protection in the parish. And it goes on to list a number of things. I believe, I don't see it here, but I know that it is a gap that we need to fill at the parish level in terms of providing data to the municipal corporation. And therefore, I'm suggesting that some of these studies could benefit the municipal authority as they understand the context in which they are operating and what are the real needs of the residents in the municipality, so that as they look to fashion programs, it will respond to the needs and to what is actually happening in the municipality. I believe that too often as government, we do research and studies and the information resides, yes, it's with PIOJ, it's with other agencies, but we do not in a meaningful way provide it to the local authority so that they can act taking into consideration what is happening at the local level that they need to respond to. So I also want to make sure that I place that on the table. Yeah, I'm going to come to that. That is page 24. Yeah, absolutely. I think I spoke about 23 and 24 already, about the caution and the formal warning and how we move to something that is more meaningful and might be more effective than simply a caution and a warning, but how we pull these youngsters in and put them on a path that prevents their behavior from escalating or deteriorating. On page 40, I think is the schedule. Quite frankly, I think the member from Westmoreland spoke about the cultural norm of really always wanting to exact justice and a price when individuals have committed a wrong. And for that reason, I believe it is extremely important as we staff the Child Diversion Office and as we establish child diversion committees to make sure that individuals who are members are individuals who understand where we are going and who are not of the old mold. Because if you staff it or people it with individuals who really are more about retribution than the kind of rehabilitation that is required now, absolutely, then we would have defeated we would have. And we have seen that certainly in some of the other agencies that we have set up who don't believe in what they have been asked to do. At this point, I don't want to name one that is really a travesty that prevents us from moving on. In terms of the schedule, the first schedule, 1A says that any offense under the following provisions of the Sexual Offences Act, A, Section 10, sexual intercourse with person under 16 is a diversion offense. And as I read it, I was wondering how would a 16-year-old having consensual sex with a 14-year-old be viewed in relation to an 18-year-old having sex, I think that's how you call it, with a 5-year-old. As it is here, it would seem to me that they would not be treated differently. And I believe that that could not be the intention of this bill. That's certain, because as it is here, it says nothing more. And certainly I would expect that sex between an 18-year-old and a 16-year-old is a different kettle of fish from between a 16-year-old and a 5-year-old, for example. And I would want to know that this bill would have a way of dealing with it. I don't see it, and therefore I become extremely uncomfortable not seeing it. No, but I'm saying that that is, as it is here, I am extremely uncomfortable with how it is. Another offense which is described at 7-8. At 8, rather, at 8. At 8 in the first schedule. Number 8. Any other following offenses, and it's under the Trespass Act. And Section 6, which is 8B, simply says squatters. And I wonder what exactly does that mean. And forgive me because I am aware of how often individuals who are seen as squatters or who live in a squatter community are immediately viewed and treated by our law enforcement agent officers, by others in society. And I want to make sure that what is there is not another pretext for individuals who are already living on the margins to be further marginalized. And so I right, and I'm saying again, since it just says squatters, I'm raising that because I am well aware of what sometimes happens when individuals step into a community that they see as a squatter community and how those individuals are treated with disdain, always never given the benefit of the doubt, always thought to be criminals, and that kind of a thing. And I want to make sure that this is not an excuse for more of the same. And so I raise that. I also, as I was looking, I see some of the offenses, and I was wondering, given what we have noted happening in our education system, why none of, we have attacks on different, it says whether it is aggravated assault on women or children. I'm still in the first schedule. I'm still in the first schedule. I'm still in the first schedule, yes. So for example, clause 2, just listing the kind of offenses, I was wondering why we did not have anything that also included what would take place in an educational institution.
No, these are inclusive, these are included offenses.
Yes. Yes, and I'm wondering why included in it is nothing that would, for example, in recent times we have been seeing a lot of teachers, for example, complaining of the kind of behavior, attack, assault of some of our students. And I'm wondering then, if we know that to be happening, if that is not a point at which we could intervene, and therefore something that the Act could actually also deal with. So, in all, as I said earlier, I support the intent. I'm just concerned about the issues that I have raised, and I hope that they are not treated in a trivial manner, because for me, some of them are, I think, very important, because, and especially that point of cultural relevance. I really, if I did not know that this bill was before the Jamaican Parliament, there's nothing in it that would suggest to me that it has taken, and if I did not read the policy itself, which included some of those things, I would not think that it is culturally relevant. And I'm concerned about that, because I believe that delinquent behavior amongst our youth is such a big problem that this has to be part, or has to be a point at which we begin to claim back our youth. And I don't think that we start early enough in terms of what is before us. Thank you very much.
Mr. Speaker, two more. Mr. Speaker, I rise to lend support to the Child Diversion Act 2018. Mr. Speaker, as an attorney at law with some 18 years practice, I can speak to the atrocities that have been meted out to many of our nation's children within the justice system over the last 18 years. Mr. Speaker, my attention this morning, when I listened to Minister Green in his presentation, this afternoon, sorry, when I listened to Mr. Green give his presentation, was immediately drawn to a matter in which I acted for 7 young men who were attending the Kingston Technical High School at the time. Mr. Speaker, the boys were arrested and charged and imprisoned for the offenses, the minor offenses of assault, disorderly conduct, etc., Mr. Speaker. And when the matter came to my attention and I went to court, the boys were remanded into custody for 7 weeks. 7 weeks. 7 weeks. I went back to court and indicated to the judge that I was going to appeal her decision to the Court of Appeal because I thought it was completely unjust. My Lord, I'm sorry, my Lord, Mr. Speaker, I'm sorry, I didn't need to Mr. Speaker, having heard my submissions, the judge changed her position and she agreed to give all 7 boys bail with a condition attached that the boys submit a book report to me as their attorney every single Friday. My Lord, they were to read a book because part of my argument was that at some point we need to try and save the young men in this country. And I find that young men, they don't read enough, or they're not encouraged enough to read. And if they had a program, which is what this child diversion program is aimed at, if they had a program to guide them, then certainly they would not get into trouble, or less likely to. So there was a headline report. The news reports, even as far as Barbados, carried it. Schoolboys to do schoolwork or go to prison, or schoolboys get bail, but a condition is there to do their homework, do their book report. And Mr. Speaker, every week those 7 boys, they read a book each week, and they took that report to me. I read their reports, and I graded them. I made further presentations to the magistrate at the family court at the time. What I will say is that at the end of less than a year, all 7 boys were acquitted of the minor offenses that they were charged with. This particular bill, when we consider young children, I have seen 14-year-old boys and 15-year-old boys dragged into court because they experimented with a young girl, sometimes 14 as well, 15, sometimes 16, sometimes, 14, sometimes 15. And what we have, Mr. Speaker, is that we have a lot of young men who have gone through the system. It's embarrassing for them, it's embarrassing for their family. It also costs the parents a lot of money to retain counsel, Your Honor, Mr. Speaker, to try and get the good names of their children, to get their children out of the criminal justice system. So, in looking at this act, Mr. Speaker, and what it intends to do, I stand here not just as a member of Parliament, but as an attorney at law, to give it my full support. I have spoken to some of my colleagues whilst we were in the chambers. I spoke to some of my colleagues via WhatsApp, and just to get their opinion on the matter, and they welcome it for what it stands to achieve. We will get our young men in particular out of the criminal justice system into a program such as this, where the guidance, because sometimes they say that, boy, the pitney bad, but if the child just had that element of guidance or that support system, because the truth of the matter is that, I recall the private member's motion that I raised in the House last year as it relates to mandatory parenting seminars. In particular, we can start with persons who are on the PATH program. Without mandatory parenting seminars, we are left with households that have 6, 7, 8 children, single families. Sometimes it's the grandmother who are raising them. They're on the government's PATH program, and there's no parental guidance or not sufficient family support. And so this particular program can catch, to use that word, some of them in a diversion program. And I have no doubt that our country will be even the better for it with a bill such as this in place, Mr. Speaker. Those are my submissions.
Thank you, Mr. Speaker. I had the benefit of not only sitting on the committee when I was Minister of Youth in the past administration, but also sitting on the committee when we did it over the last couple of years. And I stand here feeling very privileged as a parent and as a former minister to be a part of this House to pass this bill. But there was something in the committee that troubled me. And there's something that still troubles me because of my experience as a minister and some of the things that I saw. There is no doubt that many of our children were remanded for uncontrollable behavior under the law the way it was at that time. And so you would have parents who bring their children to police stations and then tell the court that they want them to be remanded, and many of the children would get lost through the system. But there's one particular thing, and at the risk of being controversial in the eyes of what many sometimes don't understand, there are two laws or two acts in this country that give our boys a hard time, our little boys. And under the act, essentially, under the Offenses Against the Persons Act of 1860, a boy cannot be raped in this country, because the way we define sexual intercourse in this country is the penetration, it's vaginal penetration. And so what happens is, when I was a minister, and I'm not sure if the current Minister of Youth, when we were heading the CDA, we saw young boys who were raped. The maximum fine for a young boy, or for a rapist, in quotes, of a boy, a little boy, is 10 years. When you look at the Sexual Offences Act of 2009, you can get up to 15 years for a girl and maximum life or imprisonment. Minimum is 15 years. And so there's a disparity between how we treat sexual offenses on a boy and sexual offenses on a girl. And it is something that we have run around because, for some reason, it is an uncomfortable discussion that we have as legislators. But it's a real problem. It is a real problem. I've seen 11-year-old boys raped. I've seen 12-year-old boys raped by people they trust. And they're scarred because they can't talk about it, because of the stigma attached. Even in our Charter of Rights, it is almost, every Jamaican is enshrined with almost God's purpose for living freedom in this country, except for two things. And you can look up what those two things are. A woman has to marry a man, and two men cannot be together. And it goes into our other laws because somehow we feel that if a boy is raped, the maximum sentence is 10 years. Many of them, when they go to the hospital or the police, they tell them that them can't deal with that. So we have to find a way, if we're really going to look at some of these things, to look at the discrepancies. But I support this bill wholeheartedly. But there's a real and honest conversation that we must have about our boys in this country. Thank you, Mr. Speaker.
Mr. Green.
Mr. Speaker, with the permission of the House, I would ask for the suspension of the debate. And when we return, I will close and then go to the committee stage.
All right, Mr. Speaker.
1 minute. Those in favor? Those against? The ayes have it.
Mr. Speaker, we now turn to the International Business Companies Act, where the member from Central Manchester will make his contribution, and he has given a commitment to be as brief as possible, as we are well into the evening and we have an important matter to deal with in the fisheries bill. So, over to you, member.
Mr. Bunting.
Thank you, Mr. Speaker. I noticed the House leader didn't extract that commitment from anybody else who was contributing this afternoon, but so be it. Mr. Speaker, the Act is designed to attract and facilitate a wide variety of international business activities. IBCs may serve as holding companies for international assets, including intellectual property rights, real property, and the shares of other companies. IBCs may be used for assets protection, licensing and franchising to conduct international trade, investment activities, and as special purpose vehicles in international financial transactions. Mr. Speaker, I'm quoting from the Memorandum of Objects and Reasons of the bill to provide for the incorporation and operation of international business companies. Now, Mr. Speaker, you will recall that this bill and its companion bills, or what are now acts, the ones that have been passed so far, have gone through an elephantine gestation. I first recall coming across this idea when I became chairman of JAMPRO in 2006, and it had been a pet project of my predecessor, chairman. In 2008, the House Leader, who was then Minister of Industry and Commerce, brought the initiative to Parliament and spoke extensively on it, and I believe he had a feasibility study that was conducted by an international expert. It was 2008. I will confess, I expressed some skepticism at the time because I thought we were late to the game. Bahamas, Cayman, Bermuda, Barbados, and St. Lucia, and I believe Belize, this is not an exhaustive list, all had some version of offshore banking, offshore insurance, offshore finance, or international business companies of some types. Different regimes, but all catering essentially to the same market. But in the interim, a great deal of time and effort has gone into the development of this legislation and the companion pieces of legislation, as well as the establishment and the operationalization of the Jamaica International Financial Services Authority. From memory, I believe we're spending, or certainly in the budget, there was an amount of about 60 to 70 million per year for the operation of the authority. What this suggests, Mr. Speaker, is that over this decade or so, since the initiative was first announced by the House Leader in his then capacity, we've spent hundreds of millions. Let me be more hopeful. We've invested hundreds of millions in terms of resources, whether in money or in drafting time and attention, the time and attention of this Parliament. So it is in that context that I want to ask the Minister to, in his closing, to expand on a few areas. First thing I want to ask the Minister, is this the remaining key component in the suite of legislation which is required to support the regime under the Jamaica International Financial Services Authority? And, well, I'll use GIFSA for short. And if it is not, could you explain what remains to come? I know we have passed from memory, let me see if I can remember. I know there was the partnership bills, two different ones for general and limited partnerships. And I believe there were a number of corporate services and trusts, etc. The member from South St. Andrew, I know, spent a great deal of time drafting these pieces of legislation. And I'd ask Minister that you explain, as you know, since it has been coming to the Parliament, sort of in bits and pieces, these bills, can you give an explanation of the overall scheme of the authority and its operations and how each of these fit in with the overall scheme? Then I would reference another paragraph in the memorandum on objects and reasons, the penultimate one. And it says the government shall earn in corporation, filing, and annual renewal fees with respect to IBCs. And Jamaican professionals who provide accounting, legal, and other services will benefit from business opportunities arising from the establishment and administration of these entities. We have taken this sort of unfaith for the last decade. I don't believe we've started to generate any income to this point. And I would be interested to hear what is the medium-term projection for government revenue in these categories. Or if you can as well, also speak to projected income to the profession, to the professionals, such as the lawyers and the accountants, and the incremental employment which this may facilitate in the medium term. I'd also like, Minister, to speak a little bit to the tax regime that will govern these IBCs. I know, generally speaking, they're usually in either a low tax or a zero tax environment. We've seen where, for example, St. Lucia has the case where you can opt for a 1% or a 0%. And if you opt for the 1%, then it becomes attractive from the CARICOM tax regime perspective that other CARICOM countries and nationals of other CARICOM countries other than St. Lucia find it attractive to establish IBCs in St. Lucia. I want to inquire whether we now will be able to do the reverse, that we can provide that for CARICOM nationals or nationals of St. Lucia, for example, who can't take advantage of their own regime, just as Jamaicans will not be able to take advantage of this regime. And finally, Mr. Speaker, as I said earlier, this bill represents an effort across administrations. So I'm really not making this into any partisan issue. I myself have seen it evolve from what started out as sort of a more offshore banking, offshore finance sort of approach, concept, to more a sort of service concept, almost sort of a outsourcing for the professions or the professional work that supports some of these offshore centers. And I am hopeful that we will be successful. But rather than us going on hope, I'd like you to also in your closing just summarize what you see as the competitive advantages that we will have under this regime, which is now substantially complete, I hope, and relative to all the other countries, as I said, who have been embarked upon this road for decades: Bahamas, Cayman, Bermuda, Barbados, St. Lucia, BVI, all in this region. Because I do recall in the original debate, I pointed out that having participated myself, not as a parliamentarian or legislator, but as a practitioner back then, in a panel, it was a Euromoney conference in Barbados. I participated in a panel on offshore banking, and every other panelist was quite clear that they didn't think that Jamaica, or Trinidad for that matter, or Trinidad and Tobago, would be ideal or attractive centers for this sort of offshore financial center. So I would love if the minister would in his closing, point out what we see as our competitive advantages relative to other players in the region. Thank you.
Mr. Speaker, let me just say that, and the speaker before me spoke to the history, the evolution of his own thinking and understanding on the subject matter before us. But certainly by the time it came to my time at the wicket, so to speak, a number of things had indeed changed. Among them was the fact that the legacy tax haven, those who had been involved in the first phase, so to speak, had by now begun to run afoul of the changing environment, including the OECD, developments in the OECD countries around tax-based tax erosion and the challenges that were very, very much now apparent with the tax havens and tax erosion. The opportunity that this provides for us, and where Jamaica has shifted its focus, is away from the tax havens to a service level activities, recognizing that there is an opportunity for our professionals to provide service, because Jamaica had the depth and the training, the manpower, the skilled labor force to service these international and offshore bodies. And so, in effect, rather than being a tax haven, we have shifted our focus on being very compliant with the international requirement, international regulations, and to focus our attempt on the services. To be consistent, and the framework, I believe, is a coherent framework from my point of view, because it addresses the whole issue of business process outsourcing, issues like logistics, where it's a service-oriented activity. The special economic zone that has been established is an integral part of that ecosystem. And part of how these IBCs, for example, must operate and will operate, to my mind, is in the context of the special economic zones that are, some of which will focus not on activities in the domestic zone, but for extra-regional activities. Recalling that the SEZ operate in the outside of the customs zone and into an area that is really confined or defined as international for purposes of certain business activities. And I think that the opportunity, the Minister, I'm sure, when he comes to finalize and to respond, will be able to see that there is a body of work that was done to support this activity and to ensure that Jamaica is in a competitive situation, given the fact that these other jurisdictions that had gone out way earlier have now found themselves caught out, so to speak, and not in sync with the evolving international norms affecting this particular area. So it gives Jamaica an opportunity, I believe, to being compliant with the international regulation, while at the same time creating an opportunity beyond the marginal to really impact on the opportunities for our professionals and to deepen the service provision, providing services to the international, to IBCs and other international regulations. So I think there's a body, there's a framework. We have looked at the various modalities that will interest the international investor and to give them the options that they need and that in fact they are used to in operating in this zone. I'm not sure, I think we should be very close on to, if not at the time I was here, it was about a suite of about 8 pieces of legislation. This may have been about maybe 7th or close to that, I would believe. So that we should be very close to building out that suite of legislation that can ensure that the international financial services sector and the authority can become operational by now. So I think that we need to bring them to the Parliament very quickly. We need to implement them, but there is indeed, to my mind, and certainly to my satisfaction, an opportunity for Jamaica to seize in the context of the new sectors and industries that we have been building out consistently over the last several years. Thank you, Mr. Speaker.
Thank you, Mr. Speaker. Permission to speak in a seat other. Oh,
sorry, sir. Just, Mr. Speaker, just quickly, I have a few points which I'd like to just. Okay. All right. Mr. Speaker, I just want to endorse what has been said on this already. It is a matter of some sadness, really, for me, that the 2 partnership acts which were passed, I don't know, a year ago perhaps, are still not in effect because the regulations are not in place to allow them to come into effect. And I think that's also true of the Trust and Corporate Services Bill. It has come to my attention as well that for Jamaican partnerships to take advantage of the partnership legislation by registering as, for example, general partnerships, there's going to have to be an amendment, in the case of law firms anyway, to the canons under the Legal Profession Act. And I think that needs to be done soon so that they can establish partnerships under and with the benefit of limited liability, especially in a world which is increasingly complex and litigious and where we're doing a lot of cross-border transactions and so on. The world has, all the major countries in the world have gone the route of allowing professionals to establish limited partnerships, and we should, I think, follow suit, but it requires a simple amendment to the canons, and I would ask that that be looked at as a matter of urgency by the government. And on this bill, there are a couple of points I just wanted to point out, Minister. A very important section in this bill is Clause 12, which sets out what an IBC incorporated under this legislation can do. And one point I noted in 5, subsection 5 on page 12, it says, subject to the provisions of subsection 6, a company shall not carry on business of any kind or type, and then it has the words, with a person in Jamaica. I'm not sure why those words, with a person, are necessary. I think the idea is that it should not carry on business of any type or kind or type in Jamaica, but I don't think the words with a person are necessary there, and potential. It's 12.5a, 12.5a on page 12. Yeah. And subsection 6, which follows, is the exception to that rule. And there's a lot of things that are allowed without being deemed to be carrying on business in Jamaica. And they're quite extensive, including things like owning and leasing property, and so on. But I would, for my part, have suggested that that list, instead of being written in the Act, should be in a schedule which can be amended by order subject to affirmative resolution. Why? Because this could impact the fiscal base of the country if we get this wrong. And if people start to use loopholes to incorporate IBCs here, take advantage of the beneficial tax regime, which we haven't heard the full details of, but which we're pretty sure will be lower rates than apply to domestic companies, but are still doing some kind of domestic business. So I suggest that you consider having subsection 6, that list put in a schedule which can be fixed quickly if you need to fix it. While on the subject of that list, in 6C, which is one of the things that is permitted, it says the company, well, I'll read the opening words. It says, notwithstanding subsection 5A, a company shall not be treated as carrying on business in Jamaica by reason only that, C, the company makes or maintains deposits with an entity licensed to carry on banking business within Jamaica. And I would suggest, sir, that we expand that to include holding of investments with or through an entity licensed as a securities dealer under the Securities Act. So that if those firms, if they have cash that they want to invest here, they're not limited to putting the money on deposit with a bank, but they can also support the local capital market, which I think would be a useful thing. And I don't see any harm in that because they are allowed to own or lease property in Jamaica, and property is not limited to real property. So this would at least allow the local securities industry to benefit. I'm not going to pick up any minor little points. I'll do that in committee. But the next substantive point I wanted to make, it's quite a bulky bill. Another time. Eh? Thank you, House Leader. Your patience is noted. Yes, this was one thing I wondered was clause 8.1 of the bill says that the word incorporated or the abbreviation Inc. shall be the last word or part of the name of every company under this act. So it has to be, you know, DV Inc. or DV Incorporated. And then I was looking at, huh? Well, you never know. You know. Come with a good idea. But in clause 120, there is an important provision that allows companies which are incorporated abroad to migrate and come under this act, which is a very good thing. And is part of what we hope will happen if we have a competitive regime here that attracts such companies. One of the things that's required in doing so is for that, let us say St. Lucia company or Cayman or wherever it may be, Delaware, it will have to make amendments to its original or restated articles of incorporation and so on, or any other instrument necessary to make the articles of continuance conform to the laws of Jamaica. And the question I had for you is this: does that mean that if they have, for example, the word limited in their name, are they going to have to change their name to be registered here by continuance? And if so, I think that might be a disincentive to them coming, because if they're well-established companies, they may not want to change their name. And I don't really see why that should be necessary. So I would suggest that if you agree with me that it really shouldn't be a requirement, we could make it clear in 120 that that is not a requirement for them to change their name to do that. There's one question I want to ask. In clause 127, Minister, which is on page 107, clause 127 on page 107, and this is to do with liquidation and dissolution, we mandate that a trustee, as defined in this part, is a person who is licensed and appointed as such under the Insolvency Act here, or the government trustee appointed under Section 227 of the Insolvency Act. And I just wondered, if you have, for example, a large concern, a multinational business that has operations in many countries of the world, is a complex business with a very large turnover, and wants to be domiciled here, or at least registered here, because our regime is attractive. if the winding up regime requires that the persons who would be responsible for the administration of its affairs in insolvency must be a Jamaican firm or Jamaican practitioner, that might be something that an advisor, an international advisor advising them might say, that might not be what you want, because the complexity and scale of those, I wouldn't say we should exclude our people, but I think it should be open. I don't think we should force them to have to use that, especially since they're not doing business in Jamaica. It doesn't make sense really, because if they're not doing business in Jamaica, most of their assets presumably will be outside of Jamaica. So why require the practitioner to be a local practitioner? And that may need some thought as to how you deal with it, but I think requiring it to be an insolvency practitioner registered under our Act could be a disincentive. And yeah, man, and I'll just take them in committee, yeah. And yeah, because they're typos and stuff. I think those are the only sort of bigger points. Oh, there's one other large point, and it is this. It's clause 190 on page 140. Clause 190 on page 140. It says an appeal lies to the Court of Appeal from any order made by the court under this Act, okay? So if, for example, there's a shareholder dispute or any other kind of corporate dispute involving an entity incorporated under this, it's the jurisdiction to hear the matter is the Supreme Court here, and an appeal lies to the Court of Appeal here. But I can imagine, again, from an attracting investment point of view, that the idea of being able to have appeal to the final court, which happens to be the Judicial Committee of the Privy Council at the moment, and we hope one day soon will be the Caribbean Court of Justice, whatever it may be, that I don't think we should preclude, because I think investors are going to be concerned that there's only one level of appeal, whereas other Jamaican companies don't have that limit. So I think we should revisit that. So, Mr. Speaker, one of the last things I did when I was in Mr. Chuck's job was dealing with this piece of legislation, and it came to LegCom in a very crazy state because they had drawn large chunks of legislation from different jurisdictions and tried to meld them together, and it was incoherent and problematic, and we spent a lot of time trying to resolve all of that. We got about 3/4 of the way through, and then, you know, the 1.5 came, and the rest is history. I'm glad that the final quarter was done, and we're here. This is really the central piece of GIFSA. This is the central piece of GIFSA, and it can't get off the ground without this. But I endorse what member from Central Manchester said about the overall strategy that we're pursuing in all this effort. We need to be very clear on what it is, what our niche really is, and how we're going to take advantage of all the hard work that has gone into preparing this and the other bills. Thank you, Mr. Speaker.
Mr. Speaker, we will bring down the curtain on today's sitting by asking the Minister with responsibility for agriculture, industry, commerce, and fisheries to deal with the protection of geographical indicators, Amendment Act 2018. We wanted to do the fisheries bill today, but time is on us, and the member who is the opposition spokesman would prefer for it to be set at another time, when his contribution perhaps could be far more fulsome. So with regards to that, we will ask the Minister of Industry, Commerce, Agriculture and Fisheries to make his presentation on the Protection of Geographical Indicators Amendment Act 2018.
No, I don't need it. Thank you very much, Mr. Speaker. Mr. Speaker, the matter,
Mr. Shaw.
The matter before us is for the Senate amendments to the bill shortly entitled the Protection of Geographical Indications Act 2018, that it be now considered and approved. It has been tabled. The amendments were tabled and is on the order paper. And they are very simple amendments, Mr. Speaker. In Clause 5 in subsection 2 of the proposed new Section 7A, simply delete the word first. In Clause 7, delete the word publish and substitute, therefore, the word published, would add an ED on that. In Clause 10, delete from subparagraph 3 of paragraph 6 of the schedule the words direct a member of the committee to proceed on leave of absence if the member, unquote, and substitute, therefore, the words revoke the appointment of a member if that member, end of quotation. In paragraph C of the amendment to Form 4, insert next after the words Note 4, the words and renumber Notes 5, 6, and 7 as Notes 4, 5, and 6. So, Mr. Speaker, these are the minor amendments that have been circulated, and I would now move for the approval and adoption of this bill by the Honourable House.
The question is that the Senate amendments to the bill shortly entitled the Protection of Geographical and Indications Amendment Act 2018 be approved. Those in favor? Aye. Those against? As of it. Amendment put for
Mr. Speaker, it is not intended to do any further business today.
Minister, just a minute, please. You're not going to sign it today.
So I ask that this Honourable House be adjourned until April 24th, when the sectorial debates will begin, at which time the Minister of Industry, Commerce, Agriculture and Fisheries will open the debate and make his contribution. Thank you very much, Mr. Speaker.
The motion is that the House be now adjourned until April the 24th at 2 p.m. Those in favor? Aye. Those against? As this Honourable House now stands adjourned until the 24th of April, 2 p.m.
You're watching PBCJ, the People's Station.